Chapter 2, Human Rights System Sad Face, Substantive Rights, Institutions and Procedures. 2.1 The Universal System, the UN System 2.1.1. The Legal Framework A. The UN Charter adopted on the 26th of June 1945, the United Nations Charter was designed to establish the foundations of a new peaceful world order. Drawing lessons from the appalling atrocities of the Second World War, the Charter's primary aim was thus to save succeeding generation from the scourge of war, preamble, paragraph 2, and to ensure the maintenance of international peace and security. Within such broad and ambitious objectives, a respect for human rights and fundamental freedoms found its significant though ambivalent reflection. The Charter has demonstrated not only a move towards the lasting and stable internationalization of human rights, but it has also implied their contribution to ensuring the establishment of the peaceful, post-war world order. Under the Dumbarton-Oaks proposals for the United Nations of 1944, the four powers intended to have rather a general reference to human rights. Finally, during the San Francisco Conference, more extensive references to human rights were included in the Charter, albeit this compromise was achieved at the expense of less imperative formulations. Finally, the Charter refers to human rights in altogether 7 provisions of diversified content and character, paragraph 3 of the Preamble, Article 1, 3, Articles 55 and 56, Article 76, c, Article 13, 1b, Article 62, 2 and 3, and Article 68. As reflected in the preamble to the Charter, the United Nations were guided, among others, by the motive to reaffirm faith in fundamental human rights, in the dignity and worth of the human person, in the equal rights of men and women and of nations large and small. Preambular paragraph 3. Having declared their lofty motives, the United Nations granted respect for human rights the status of one of the fundamental purposes of the organization. The Charter sets out that the purpose of the United Nations will be, inter alia, to achieve international cooperation also in. The Charter sets out that the purpose of the United Nations will be, inter alia, to achieve international cooperation also in 22. Promoting and encouraging respect for human rights and for fundamental freedoms for all without distinction as to race, sex, language, or religion, Article 1.3. More specific rules of conduct aimed at the accomplishment of these tasks are contained in 3 sets of provisions of the Charter, on international economic and social cooperation, Articles 55 and 56, on the international trusteeship system, Article 76, c, and on the functions and powers of the UN organs in this sphere, Article 13, 1b, Article 62, 2 and 3, and Article 68. Of particular consequence is the first set of human rights provisions, which relates to international economic and social cooperation laid down in Chapter 9 of the Charter. Its Article 55 sets forth that with a view to the creation of conditions of stability and well-being which are necessary for peaceful and friendly relations among nations based on respect for the principle of equal rights and self-determination of peoples, the United Nations shall promote, inter alia, universal respect for, and observance of human rights and fundamental freedoms for all without distinction as to race, sex, language, or religion, Article 55c. As a direct extension these provisions, Article 56 provides that all members pledge themselves to take joint and separate action in cooperation with the organization for the achievement of the purposes set forth in Article 55. As far as the second set of provisions is concerned, it was provided that one of the basic objectives of the International Trusteeship System, chapter of the Charter, will also be to encourage respect for human rights and for fundamental freedoms for all without distinction as to race, sex, language, or religion, and to encourage recognition of the interdependence of the people of the world, Article 76, c. Within the third set of provisions, the Charter translated its objectives and role in the field of human rights into the functions and powers of number of UN organs. Thus, the General Assembly was assigned the tasks of initiating studies and making recommendations for the purpose, inter alia, of promoting international cooperation in the economic, social, cultural, educational, and health fields, and assisting in the realization of human rights and fundamental freedoms for all without distinction as to race, sex, language, or religion, Article 13b. Thus, the General Assembly was assigned the tasks of initiating studies and making recommendations for the purpose, inter alia, of promoting international cooperation in the economic, social, cultural, educational, and health fields, and assisting in the realization of human rights and fundamental freedoms for all without distinction as to race, sex, language, or religion, Article 13b. 23. Another principal organ of the United Nations, the Economic and Social Council, was entrusted in Article 62 with a function to make recommendations for the purposes of promoting respect for, and observance of, human rights and fundamental freedoms for all. Paragraph 2, and to prepare draft conventions for submission to the General Assembly, with respect to matters falling within its competence. Paragraph 3. For organizational purposes, Article 68 provides that the Economic and Social Council shall set up commissions in economic and social fields and for the promotion of human rights, and such other commissions as may be required for the performance of its functions. It may be concluded that both the number and the scope of human rights provisions in the UN Charter is prima facie quite impressive in itself. This becomes particularly evident when the UN Charters is contrasted with its predecessor, the Covenant of the League of Nations, which was entirely silent on human rights issues. However, as a reflection of the compromise reached at the San Francisco Conference in 1945, the human rights clauses of the Charter show signs of ambivalence and vagueness. In order to properly appreciate the legal character and significance of the UN Charter human rights provisions, please read the following extract from. Although both in the preamble and in Article 1.3, the Charter sets out nothing but the pious intentions and purposes of the United Nations in the field of human rights, it nevertheless translated these general statements of a common intention into several specific obligations set forth in its operative part. Thus there is nothing in these provisions, particularly in the preamble, that would add to or subtract from the operative provisions of the main text of the Charter. It is significant in itself, however, that the Charter conferred on human rights the rank of not an ad hoc but of a long-term and constant objective of the United Nations. Thus the Charter assumes in essence a permanent and dynamic attitude on the part of the United Nations, both the organization and its members, towards respect for human rights. This conclusion may directly be inferred from the content and nature of all 7 human rights provisions. In particular, it is confirmed by the mandatory wording of Article 13.1, initiating studies and making. In particular, it is confirmed by the mandatory wording of Article 13.1, initiating studies and making. 24. Recommendations by the General Assembly, Article 55 in conjunction with Article 56, Action for International Cooperation, and Article 68, explicit mention of setting up a commission, in the field of human rights. One of the innovative approaches reflected in the human rights provisions of the Charter is their formulation in an interdependent context as one prerequisite for ensuring international peace and security, friendly relations among nations, welfare of peoples and other socio-economic objectives. Human rights were thus placed against a broader background of political, economic and social aspects. This linkage is most clearly envisaged in Articles 55 and 56. Although the very relationship between peace, development and human rights is not entirely a new concept, it lifts this interdependence to the level of the organization's primary purposes. In other words, obligations of international cooperation for the achievement of these values and purposes created a normative framework and potentials for further joint and separate actions by the United Nations and their members. Human rights clauses in the Charter exhibit also clear signs of weakness and vagueness both politically and legally. Irrespective of its lofty statements, the Charter has not adequately addressed the problem of colonialism. The whole arrangement concerning a trusteeship system and human rights, Article 76, was nothing but a reflection of the then colonial powers' double standards. The international community learned much about the inhumanity of Nazism and communism, but at the same time accepted colonialism as another malaise and enemy of human rights based on a respect for inalienable and inherent human dignity. In assessing the 7 human rights provisions of the Charter, one should also point to certain weaknesses in their legal character. While the Charter refers throughout its text to the concept of human rights and fundamental freedoms, their definition is missing, nor does the Charter make any mention of the machinery to be used to secure their observance. This weakness appears, however, to be of significance since the drafters of the Charter were well aware from their domestic constitutional and political background what the terms human rights and fundamental freedoms had meant in at least their commonsensical meanings. In addition, one may reasonably question the very indispensability of elaborating such a definition. The real problem that remains. 25, is thus not the general and descriptive definition of human rights and fundamental freedoms as such, but rather defining their extent, the identification of their precise content and their defining their extent, the identification of their precise content and their implementation mechanisms. These demands were largely remedied and satisfied with the adoption of the Universal Declaration of Human Rights, the international covenants and other instruments, including the establishment of conventional and extra-conventional monitoring procedures. Furthermore, while there should be no doubt that all these provisions of the Charter, whatever their wording, are legally binding treaty provisions, their imperative and binding force is diverse in nature. In the human rights clauses of the UN Charter there is a somewhat general, cautious and open-ended manner in the way they were drafted. It is no coincidence that one encounters referenced in the Charter to such terms as promoting, encouraging and assisting in the realization of, instead of tougher terms like protecting, maintaining, safeguarding or guaranteeing human rights and fundamental freedoms. Furthermore, a deliberate resort to these open-ended terms was coupled with attributing no power functions to such organs as the General Assembly or the Economic and Social Council, which shall initiate studies and may make recommendations, see Articles 13 and 62. During the San Francisco Conference, proposals that the Charter should assure not only promotion and observance, but also protection of human rights, was defeated because some delegations believed that such language would have inappropriately raised expectations in relation to the United Nations action on specific human rights problems. There is actually no doubt that the factor which mostly determined the open-ended formulation of human rights clauses was the prohibition, contained in Article 2(7), of intervention by the United Nations in matters which are essentially within the domestic jurisdiction of states. On the other hand, however, already in 1945 this principle was construed in terms of a prohibition against exerting direct pressure through force or the threat of force. Thus the very discussion, study, enquiry or making recommendations on human rights problems does not constitute an intervention in the sense of Article 2(7). Although this interpretation was challenged for decades. 26, by predominantly autocratic regimes, it finally gained ground and is virtually universally recognized nowadays. But its legal basis is still controversial. All in all, these developments help to explain and clarify why among the 7 principles enshrined in Article 2 it is not possible to identify an explicit formulation of the principle of international respect for human rights, while the principle of the prohibition of interference in the internal affairs of states eventually prevailed. It is nevertheless possible to submit that a series of detailed provisions in the Charter argues for the recognition of the international respect for human rights as a key principle of the United Nations. The experience of the United Nations has shown that harmonization of Article 2(7) and the human rights clauses of the Charter have proved to be feasible. Notwithstanding the apparent weaknesses of human rights clauses in the UN Charter and their largely lex imperfecta character, one should not overlook the fact that they remain binding international legal obligations for all the member of the international community. B. The UDHR. The adoption of Declaration of the Human Rights was envisaged as the very first item on the United Nations agenda within the program of the International Bill of Human Rights. The task of preparing a declaration was given to the Commission on Human Rights, which started its work in 1947 and established for that purpose a drafting committee of 8 members chaired by Mrs. Eleanor Roosevelt. In 1948 the Commission adopted the draft declaration and submitted it through the Economic and Social Council to the General Assembly. After lengthy discussions at the General Assembly and its third committee, the declaration was adopted on the 10th of December 1948 during the third session of the Assembly at the Chaillot Palace in Paris. The declaration was adopted by 48 votes in favor, none against and 8 abstentions by Russia, Czechoslovakia, Poland, Saudi Arabia, South Africa, Ukraine, USSR and Yugoslavia. Altogether the declaration was drafted and eventually adopted within 2 years. This unquestionable success might not have been achieved in subsequent years due to increasing Cold War tensions between East and West, which detrimentally affected the work of the United Nations in human rights and other fields. 27. The Universal Declaration was adopted through Resolution 217(3), which contained 5 parts. Part A, the text of the declaration as such. Part B, right of petition. Part C, fate of minorities. Part D, publicity to be given to the Universal Declaration of Human Rights, and Part E, preparation of a draft covenant on human rights and draft measures of implementation. Contained in Part A of Resolution 217(3), the Universal Declaration is made up of the preamble and 30 articles which comprise its operative part. Typically for international instruments, the preamble spells out the philosophy, motives and purposes which guided the drafters of the Universal Declaration. The preamble to the Declaration is significant for several reasons. Its fundamental message lies in the statement that recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice and peace in the world. Paragraph 1. The preamble thus refers to the concepts of inherent human dignity and the inalienable nature of human rights as the philosophical sources of the Declaration and inspirations for further development of human rights. Although such a formulation is often characterized as reflection of Western liberalism, nonetheless these concepts are discernible in all human cultures of the world. It is thus particularly significant that the preamble calls for intercultural consensus by indicating that a common understanding of these rights and freedoms is of the greatest importance for the full realization of the pledge of members of the United Nations to achieve the promotion of universal respect for and observance of human rights and fundamental freedoms. Paragraphs 6 and 7. The preamble also reflects its pre-1945 roots by pointing out that disregard and contempt for human rights have resulted in barbarous acts which have outraged the conscience of mankind. Against this background, the Universal Declaration announces the advent of a world in which human beings shall enjoy freedom of speech, belief, and freedom from fear and want has been proclaimed as the highest aspiration of the common people. Paragraph 2. The latter provisions reflect explicitly the Four Freedoms message to the U.S. Congress by Franklin D. Roosevelt in January 1941. 28. These significant statements are further accompanied by a unique formulation that it is essential, if man is not to be compelled to have recourse, as a last resort, to rebellion against tyranny and oppression, that human rights should be protected by the rule of law. It is not so much the functional link between rights and the rule of law that is innovative here, but rather the confirmation by the Declaration of the customary right of people to resist oppressive governance. Paragraph 3. Another important element of the preamble is the recognition, in its final paragraph, of the rights and freedoms contained in the Declaration as a common standard of achievement for all peoples and nations. This common standard, in French, pour commun, seems to presuppose both a common ideal and a normative reference system for the new international order. The operative part of the Declaration can be divided into three groups of provisions. The first group, Article 1, contains an affirmation of the philosophical foundations of human rights by saying that, 11 human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood. Although the significance of this provision cannot be underestimated, it is not formulated in classic legal language. In spite of proposals to have it transferred to the preamble, it was retained as the opening of the operative part of the Declaration. The second group of provisions proclaims a number of general principles. One is the principle of equality and non-discrimination, Article 2, the principle that plays a fundamental role in the whole of human rights law. The second principle relates to the concept of the duties of states in the form of the right of everyone to a social and international order in which the rights and freedoms set forth in the Declaration can be fully realized, Article 28. The third principle spells out a concept of the duties of everyone to the community, Article 29, 1, and permissible limitations in the exercise of the human rights and freedoms, Article 29, 2. And the fourth principle provides for the prohibition of activates by any state, group or person aimed at the destruction of the rights and freedoms set forth in the Declaration, Article 30. And the fourth principle provides for the prohibition of activates by any state, group or person aimed at the destruction of the rights and freedoms set forth in the Declaration, Article 30. 29. As far as substantive rights are concerned, the Declaration contains in Articles 3 to 27 the fundamental civil and political rights and freedoms, as well as economic, social and cultural rights. The catalogue of rights and freedoms of the first generation includes virtually all the fundamental civil and political rights and freedoms, Articles 3 to 21. Among these the following were included: the right to life, liberty and security, freedom from slavery and servitude, freedom from torture and inhuman treatment or punishment, the right to recognition as a person before the law, freedom from arbitrary arrest, detention or exile, the right to equal protection of the law, the right to an effective remedy, the right to a fair trial, the right to privacy, freedom of movement and residence, the right to nationality, freedom of thought, conscience and religion, freedom of opinion and expression, freedom of assembly and association, the right to property, the right to participate in the government of one's country, and others. Less extensive is the catalogue of economic, social and cultural rights, Articles 22 to 27. This contains the right to social security, the right to work, the right to rest and leisure, the right to an adequate standard of living, the right to education, and the right to participate in the cultural life. This very modest list of socio-economic rights was a consequence of strong controversies about their legal character. Nonetheless, the very incorporation of economic, social and cultural rights to the Universal Declaration has been a substantial innovation in modern international law of human rights. All in all, the adoption and content of the Universal Declaration has been a great success. The celebration constitutes the first internationally adopted catalog, and in this sense, definition of human rights. From the perspective of the normative maturity of formulations of human rights, it may be submitted that the Universal Declaration is one of the best legal instruments on human rights ever adopted. The reading of the following extract will be of a great help in understanding the legal and political status and significance of the UDHR. 30. The Universal Declaration of Human Rights was deliberately adopted under guise of a resolution of the UN General Assembly and not that of an international treaty subject to a formal ratification procedure in member states. There are, however, ongoing discussions among legal scholars as to whether the declaration has, over the years, become a legally binding instrument. Proponents of the binding character of the declaration argue for its status as a customary law. Opponents of such a view submit that the establishment of a customary international legal rule requires the existence of general, uniform and consistent practice by states followed by the emergence of an opinio iuris, that is, of a conviction or belief by states in the obligatory character of such a practice. With these requires in mind, it may be claimed that the practice of worldwide violations of human rights before and after 1948 fails to satisfy the condition on general, uniform and consistent practice by states. Some scholars submit that the binding customary nature of the declaration stems from the absence of opposition to its principles by states as reflected in their constitutions and official government statements. There is some logic in this argument, but for a formation of a custom the decisive factor is the actual practice and not lofty statements by governments, often colored with hypocrisy. Thus what matters is the deeds, and not the words of governments. It may cautiously be concluded that these endless disputes are, to a large extent, futile scholarly exercises, since the declaration itself has proved its fundamental importance without necessarily being recognized as a part of customary international law. By the adoption of the Universal Declaration, members of the United Nations have made a political commitment to implement the rights contained therein. The legal and political significance of the Universal Declaration may be illustrated by several development and tangible achievements. As a universally accepted normative reference system, the Declaration permeated domestic legal systems of numerous states by the incorporation of its provisions into national constitutions and other legislative instruments. In several newly independent states, e.g., in Africa, the Universal Declaration was included as a whole or in extensive parts in their constitutions. In the constituents of several new European democracies, e.g., Spain and Romania, there are explicit references to the Declaration as a reference system. It has similarly become a reference for domestic courts in developing their case law on human rights issues. No. Number 31. Less significant is the resort to the content of the Declaration by non-governmental actors. The domestic impact of the Declaration has thus been much wider than might have been expected of a non-binding instrument. On the international level, the Declaration has established the very first international catalogue of human rights as a common standard of achievement for all peoples and all nations. This model catalogue may thus be said to play also the role of the first definition of human rights, the definition which is missing from the UN Charter. The legal and political significance of such a function of the Declaration has further been strengthened by its adoption by the General Assembly of the United Nations. Consequently, the definition and catalogue of human rights in the Declaration may safely be regarded as a quasi-authentic interpretation of the human rights provisions of the UN Charter. The universal message reflected in the Declaration is further strengthened by the fact that some of its provisions constitute general principles of law or represent elementary considerations of humanity. Another important aspect in the adoption of the Universal Declaration has been the establishment of the basis for further international lawmaking in the field of human rights. This contribution has gone well beyond the program of the International Bill of Human Rights. In addition to the adoption of both the International Covenants on Human Rights in 1966, the Universal Declaration exerted a profound impact on the content and scope of other human rights instruments organizations. This impact may be identified not only in explicit references to the Declaration, contained usually in preambles, but above all in the very formulation of specific rights and freedoms. Altogether, the Universal Declaration opened the way for what may be regarded as the codification and progressive development of human rights in international law. The significance of the Universal Declaration has not been confined solely to influencing international standard setting in the field of human rights. It has also created opportunities for developing international procedures and mechanisms for the implementation of human rights in the United Nations. The Declaration has become the main basis and references sources for establishing the communications and investigative procedures, e.g. under Resolutions 1235 and 1503 of the Economic and Social Council. As a resolution, and not a treaty, adopted by the as a resolution, and not a treaty, adopted by the 32 General Assembly, the Declaration has become applicable to all the UN members. If the text of the Declaration had been adopted as a treaty, its binding force and palpability would have become very much more limited. Similarly, the significance of the implementation of the Declaration has been explicitly emphasized in the preamble to the European Convention for the Protection of Human Rights and Fundamental Freedoms, whose signatory governments declared their resolve to take the first steps for the collective enforcement of certain of the rights stated in the Universal Declarations. Another example of a direct reference to commitments contained in the Declaration may be found in the documents of the former Conferences on Security and Cooperation in Europe (CSCE), most notably in the Final Act of Helsinki, 1975, and other documents. Importantly, these provisions of the CSCE documents have not solely been escape clauses used to reach a compromise in diplomatic negotiations, but they have equally served as a means of establishing monitoring procedures for preventive diplomacy. The Universal Declaration of Human Rights should, therefore, be seen above all as a document that has exerted a profound and comprehensive impact internationally and domestically in furthering the promotion and protection of human rights. Its inspirational role has not yet been exhausted. See the Covenants on Civil, Political and Economic, Social and Cultural Rights. After the adoption of the Universal Declaration, the Commission on Human Rights based on the second part of the Bill of Human Rights, namely the development of norms that were undisputedly binding on those states that choose to adhere to them. The General Assembly at its first session in 1946 assigned the Commission the task of preparing an International Bill of Rights. Today, the International Bill of Rights is regarded as consisting of the Universal Declaration of Human Rights, the International Covenant on Economic, Social and Cultural Rights, and the International Covenant on Civil and Political Rights and its two optional protocols. The Commission proposed in 1950 to keep all rights in one convention. However, USA and some other Western countries argued against this proposal, and in 1951 they succeeded in persuading the General Assembly not to follow the recommendations of the Commission on. However, USA and some other Western countries argued against this proposal, and in 1951 they succeeded in persuading the General Assembly not to follow the recommendations of the Commission on 33 human rights, but instead decided in favor of two separate conventions, on civil and political rights and the other on economic, social and cultural rights. The arguments put forward by USA and others were centered around asserted differences in regard to the possibility for the individual to legally enforce his rights and the different kind of monitoring mechanisms the two sets of rights would require. In hindsight, one can question whether this decision has well served the cause of human rights. Today, most proponents of human rights instead find it essential to emphasize the interrelationship and mutually reinforcing nature of the various human rights. The tendency in the subsequent development of standards, starting already in the 60s with the Convention on the Elimination of Racial Discrimination and onwards, has been to either bring up a particular subject and regulate it in greater depth, or to take up the protection needs of individuals or groups that are especially prone to discrimination or in need of particular protection. In regard to the substantive rights dealt with in treaties or instruments of the latter kind, e.g. on refuges, against racial discrimination, against discrimination of women, on children, on minorities, this holistic approach has been followed. Accordingly, civil, cultural, economic, political and social rights are all dealt with in those instruments. It should also be noted that although the rights dealt with in the covenants are contained in two different documents, it has been emphasized in UN resolutions and documents that the covenants belong together and should be seen as a whole. In only a few instances, a state has decided to adhere only to one of the two. As of January 2001, 146 states are parties to the Covenant on Civil and Political Rights and 142 states to the Covenant on Economic, Social and Cultural Rights. The two covenants contain some identical or similar provisions, such as the right to self-determination, Article 17 both covenants, and the principle of non-discrimination, Article 2 of both covenants. Also the safeguard clauses that the rights should not be used as a pretext for the destruction of other rights, are the same, Article 5 of both covenants. Also the safeguard clauses that the rights should not be used as a pretext for the destruction of other rights, are the same, Article 5 of both covenants. 34. The International Covenant on Civil and Political Rights. The International Covenant on Civil and Political Rights contains 53 articles, of which 27 are of a normative character. It also consists of a first optional protocol adopted at the same time as the Covenant in 1906, establishing a procedure for individual complaints, and a second optional protocol, adopted in 1989 aiming at the abolition of the death penalty. As of January 2001, 98 states are parties to the first protocol and 45 states to the second. Pursuant to Article 28 of the Covenant, a Human Rights Committee is established, consisting of 18 members, who are nominated and elected by states but who serve in their individual capacity. Its mandate is to consider the reports that all states parties are under a duty to submit regularly to the committee, to consider interstate complaint and to deal with the individual complaints that may come before it under the first optional protocol. The International Covenant on Economic, Social and Cultural Rights. The International Covenant on Economic, Social, and Cultural Rights consists of 31 articles, of which the first 15 are of a normative character and the last 16 of a more procedural nature. In its normative articles it sets out many of the fundamentals for the well-being and prosperity of an individual. Each state party is under an obligation to undertake steps to the maximum of its available resources with a view to achieving progressively the full realization of the rights recognized in the present covenant, by all appropriate means, including particularly the adaptation of legislative measures, Article 27 the Covenant. A core provision is Article 11, which recognizes the rights of everyone to an adequate standard of living, including adequate food, clothing and housing, and to the continuous improvement of living conditions. Unfortunately, as the committee itself has noted, in many parts of the world there exists a disturbingly large situation. Much debate had been held on the difficulties to enforce and measure to what extent a state party is fulfilling its obligation under the covenant. However, several fundamental principles apply, e.g. the important principle of non-discrimination. Also, the exercise of particular economic, social or cultural rights presupposed or is linked to the exercise and enjoyment of rights of a civil or political nature. For example, the enjoyment of many cultural rights presupposes the rights to freedom of association, of religion and expression. For example, the enjoyment of many cultural rights presupposes the rights to freedom of association, of religion and expression. 35. The international community has in the last years pointed to the need to give increased attention to economic, social and cultural rights. The denial of these are often the first steps towards alienation and polarization in societies, which in turn lead to increased risks for violent conflict and further oppression. Any focus on measures of a truly preventive character will sooner or later embark on discussions about improved implementation of human rights, and not the least in regard to the principle of non-discrimination and economic, social and cultural rights. The Covenant on Economic, Social and Cultural Rights do not make provision for the establishment of a separate treaty body. Instead, the responsibility for the supervision of the Covenant is entrusted to the Economic and Social Council, ECOSOC. Originally, the ECOSOC delegated this work to a special group of government experts. However, in 1985, the ECOSOC decided to instead create the Committee on Economic, Social and Cultural Rights, a body composed of 18 members, elected by ECOSOC from a list of candidates nominated by states parties for terms of 4 years. Members serve in their individual capacities, and meet twice a year for sessions of 3 weeks duration. The main function of the committee, as will all others of the 6 treaty bodies, is the examination of state report. The International Convention on the Elimination of All Forms of Racial Discrimination in 1969, 7 years before the aforediscussed 2 covenants entered into force, the International Convention on the Elimination of All Forms of Racial Discrimination, CERD, entered into force after having been adopted in 1965 by the General Assembly. The convention, which as of January 2001 has 156 states parties, was the first United Nations human rights instrument outside the provisions on human rights in the Charter that established an international monitoring system, including a procedure for individual complaints. At the time of the elaboration of its provisions, the Commission on Human Rights was occupied with drafting the two covenants. The convention was essentially the work of the General Assembly itself, in consultation with various other bodies. The conclusion of the convention was a priority objective, not the least of the new member states of the UN, which had just gained their independence in the early 1960s. The conclusion of the convention was a priority objective, not the least of the new member states of the UN, which had just gained their independence in the early 1960s. 36. The convention contains 25 articles, of which the first 7 articles are of a normative character. A broad definition of racial discrimination is found in Article 1, and the Convention sets out a number of detailed prohibitions and obligations to prevent discrimination based on the grounds of race, color, descent, or national or ethnic origin. States are under an obligation to criminalize dissemination of ideas based on racial superiority and hatred and participation in racial organizations or activities. The committee established under the treaty reminded states that its undertaking was not only an obligation to enact certain criminal laws but also to ensure that the laws are effectively enforced. The international monitoring procedures are dealt with in the second part of the Convention, Articles 8 to 16. A Committee on the Elimination of Racial Discrimination, CERD, consisting of 18 independent experts created by the states parties after being nominated by such states parties, examines and comments on reports submitted by the parties. Such report has to be submitted initially 1 year after the convention enters into force for a state and thereafter every 2 years. The committee was also competent to deal with complaints of a state party about non-fulfillment of the treaty obligations by another state party. The committee is empowered to play a role of inquiry and conciliation, aiming at reaching an amicable solution of the dispute, Articles 11 to 13. So far there have been no interstate complaints. The Convention on the Elimination of Discrimination Against Women. Equal rights of women and men are a basic principle of law embodied in the Charter of the United Nations and in numerous human rights instruments in the preamble and in the provisions dealing with non-discrimination, e.g. Article 1, Para. 3, and Article 55 of the Charter. This principle is proclaimed in the Universal Declaration as well as in the two covenants, Articles 1 and 2 of the Universal Declaration, and in both covenants, but in different paragraphs. In addition, states parties specifically undertake to ensure the equal right of men and women to the enjoyment of all rights set forth in each covenant, Article 3 of both covenants. Despite this basic principle of non-discrimination and of integration of all human rights regardless of gender, developments relating to their actual implementation in law and practice have been slow. The United Nations has therefore from the outset tried to promote the necessary. The United Nations has therefore from the outset tried to promote the necessary 37 changes in regard to the equal enjoyment by women of human rights and their equal status to men. The creation of a special functional commission, the Commission on the Status of Women, and a number of legal instruments relating to the enjoyment of women of human rights has been decided upon. Such conventions have also been concluded within the framework of the International Labour Organization, ILO, governing discrimination in employment, equal remuneration, protection from hazardous work and maternity protection. The Commission on the Status of Women was established in the early days of the United Nations, in 1943. In 1967, the General Assembly adopted the Declaration on the Elimination of Discrimination Against Women, CEDAW. This was a reaction based on a growing concern that additional means for promoting and protecting equal enjoyment of human rights by women is necessary. In 1972, the Secretary General asked the Commission on the Status of Women to request the view of member states as to the form and content of a possible legally binding instrument on the subject. In 1974, the Commission began drafting a convention. The World Conference of the International Women's Year, held in Mexico City in 1975, encouraged the work in its plan of action. The plan of action called for Convention on the Elimination of Discrimination Against Women, with effective procedures for its implementation. In 1977, a draft instrument was submitted to the General Assembly, which appointed a special working group to finalize the draft. The convention was adopted by the General Assembly in 1979, which is entered into force in 1981, and has as of January 2001 165 states parties. The convention consists of 30 articles, of which the first 16 are of a normative character. The definition of discrimination against women, contained in the first article, is more detailed than in many other discrimination clauses. It was inspired by the definition of racial discrimination as contained in the Convention on that subject. In both its definition and in other provisions, the Convention on the Elimination of All Forms of Discrimination Against Women, Article 18 of the Convention, reflects the depth of exclusion and restriction practiced against women because of their sex. It identifies many areas where there have been a notorious discrimination against women, for example in regard to political and civil rights, economic rights and employment. It 38 calls for equal rights for women, regardless of their marital status. It calls for national legislation to ban discrimination. It allows for temporary special measures to accelerate the achievement of equality between men and women. The Convention recognizes that, even if women's equality is guaranteed by law and special measures taken in order to promote de facto equality, there is still a necessity to take measures to remove the social, cultural and traditional patterns which perpetuate gender role stereotypes and to create an overall framework in society that promotes the equal rights and responsibilities between men and women, including shared responsibilities in the domestic sphere. The Convention provides for equal rights of women in political and public life, equal access to education and employment, equality in access to health facilitates and an end to discrimination in the field of finance and areas of economic and social rights. The Convention also stresses the need to eliminate discrimination in all matters relating to marriage and family-related matters and stresses the social services needed, especially child care facilities, for a full participation of women in public life. The issues of gender-based violence are not specifically addressed in the Convention. The committee set up under the Convention has also addressed this subject in its general recommendation of Article 19, in which it formally extends the general prohibition on gender-based discrimination to include gender-based violence. The work of the committee in this area was further reinforced when, in 1993, the General Assembly adopted the Declaration on the Elimination of Violence Against Women. Another area of growing concerns was the search for more effective measures to combat and suppress traffic in women and exploitation of prostitution of women, a subject dealt with in the Convention, Article 6 of the Convention. The Convention establishes a Committee on the Elimination of Discrimination Against Women consisting of 23 members nominated and elected by states parties but serving in their personal capacity. The Convention establishes a Committee on the Elimination of Discrimination Against Women consisting of 23 members nominated and elected by states parties but serving in their personal capacity. 39. The Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment. Although the eradication of torture has long been a goal proclaimed by the international community, torture is still practiced in many states. A number of prominent human rights experts and non-governmental organizations actively campaign so that governments give priority to this problem. Today, representatives of basically all states agree publicly that torture is an example of human rights violation which can never be accepted. Yet the reports of Amnesty, Human Rights Watch and other human rights organizations bear ample evidence that the factual situation in police stations, prisons and military establishments is very different from the commitment undertaken by governments in this respect. Much too often, acts of torture are committed with complete impunity for the torturers. Torture is consistently outlawed in international law. The Universal Declaration states in Article 5 that no one shall be subjected to torture or cruel, inhumane or degrading treatment or punishment. In 1949, the four general conventions included a prohibition against cruel treatment and torture, as well as outrages upon personal dignity, in particular humiliating and degrading treatment, in their common Article 3. In 1955, the Standard Minimum Rules for Treatment of Prisoners were adopted by the First United Nations Congress on the Prevention of Crime and the Treatment of Prisoners. These congresses, that have convened every 5 years since 1955, have contributed in ways to the development of norms aiming at a more human treatment of persons in detention. The Standard Rules for Prisoners gives in 95 articles guidelines for the treatment of detained persons, and forbids cruel, degrading or inhuman treatment or punishment as well as corporal punishment. These standards have influenced the legislation of many countries and have, in many instances, helped to provide some measures of protection to incarcerated persons. In 1966, with the adoption of the Covenant on Civil and Political Rights, the international community unequivocally repeated the prohibition against torture. Efforts continued to reach further through developing specific and detailed measures, of normative, practical and remedial nature, against torture and ill treatment. In 1975, the General Assembly adopted a declaration on the protection of all persons from being subjected to torture and other cruel, inhuman or. In 1975, the General Assembly adopted a declaration on the protection of all persons from being subjected to torture and other cruel, inhuman or 40. Degrading treatment or punishment, which contained in its first article a definition of the term torture. Another way to proceed was to address the behavior of the various professional groups that normally were directly exposed to situations where acts of torture or ill treatment might occur. In 1979, a code of conduct for law enforcement officials was adopted by the General Assembly, which prescribes that no law enforcement official may inflict, instigate or tolerate any act of torture or other cruel, inhuman or degrading treatment or punishment, nor invoke superior orders or exceptional circumstances such as sad of war or threat of war, a threat to national security, internal political instability or any other public emergence as a justification of such acts. Article 5 of the Code of Conduct for Law Enforcement Officials. In 1982, the General Assembly adopted the principles of medical ethics relevant to the role of health personnel, particularly physicians, in the protection of prisoners and detainees against torture and other cruel, inhuman or degrading treatment or punishment. On the 10th of December 1984, another major step was taken when the General Assembly adopted the Convention Against Torture on Other Cruel, Inhuman or Degrading Treatment or Punishment, which entered into force in 1987. The convention has, as of January 2001, 122 states parties. The provisions in this convention build on elements from the other instruments mentioned above. The convention provides for a definition of torture in its first article, which includes intentional acts for certain enumerated reasons which causes severe pain or suffering of physical or mental nature for a person's, when such pain or suffering is inflicted by or at the instigation of or with the consent or acquiescence of a public, official or other person acting in an official capacity, Article 1 of the Convention Against Torture. During the negotiations, a group of countries insisted on adding a clause explicitly precluding pain or suffering arising from lawful sanctions, an exception not found in earlier instruments containing provisions relating to torture, Article 1 of the Convention. The Convention establishes a committee against torture, consisting of 10 members, nominated and elected by states parties but serving in their personal capacity, Article 2 of the Convention Against Torture. The Convention establishes a committee against torture, consisting of 10 members, nominated and elected by states parties but serving in their personal capacity, Article 2 of the Convention Against Torture. 41. G. The Convention of the Right of the Child. The welfare and rights of children have been a subject which the United Nations has dealt with since its creation. Already the League of Nations had promoted the idea of granting special protection to the rights of the child through the adoption in 1924 of a Declaration on the Rights of the Child. One of the first decisions of the General Assembly in 1946 was to create the United Nations Fund for Children, UNICEF, an organization which during a first phase dealt primarily with assistance to children affected by emergencies. In 1953 it was made a permanent body and its mandate expanded to cover development issues and the welfare of children in a more general sense. Nowadays, UNICEF regards the promotion and protection of the rights set out in the 1989 Convention on the Rights of the Child as a general framework and mandate for all its activities. The Universal Declaration of Human Rights, adopted in 1948, recognized in Article 25 that childhood is entitled to special care and assistance, and that all children, whether born in or out of wedlock, shall enjoy the same social protection. In 1959, the United Nations adopted a Declaration on the Rights of the Child, where the rights from the old 1924 Declaration were reaffirmed and further elaborated. The need to give the force of legally binding obligations to children's rights also became more evident, and in 1979, the International Year of the Child, the Commission on Human Rights started its work on the drafting of a convention. The drafting process took 10 years. The convention was adopted by the General Assembly in 1989, and entered into force in 1990. It soon received unprecedented support and achieved unique political commitments, inter alia, evidenced at the World Summit for Children in New York in 1990 and the World Conference on Human Rights in Vienna in 1993. The Convention on the Rights of the Child is the first specific human rights treaty that has achieved an almost universal adherence. As of January 2001, it has 190 states parties, and only the United States and Somalia have failed to accede to the convention. The convention consists of 54 articles, of which the first 42 are of a normative character. The convention is all-encompassing and sets up a holistic approach where civil, political, economic, social and cultural rights are included, all being of importance for safeguarding the dignity of the convention is all-encompassing and sets up a holistic approach where civil, political, economic, social and cultural rights are included, all being of importance for safeguarding the dignity of the 42 child and a harmonious development of his personality. A child is defined as every human being below the age of 18 years. Unless, under the law applicable to the child, majority is attained earlier, Article 1 of the Convention. Four general principles have guided the authors of the Convention, and later been highlighted by the Committee on the Rights in the General Guidelines as the core message of the Convention. Firstly, the principle of the full and equal value of children, and that each child shall enjoy the rights set out in the Convention without discrimination, Article 2 and 4 of the Convention. Secondly, the principle that in all actions concerning children the best interest of the child shall be the primarily consideration, Article 3 of the Convention. Thirdly, the principle of the right to life does not only entail the right to be protected against being killed but a right to survival and development, Article 6 of the Convention. Fourthly, the principle that children, who are capable of forming their own views, shall also have the right to participate and express their views, which shall be duly respected, Article 12 of the Convention. The Convention establishes a Committee on the Rights of the Child, originally composed of 10 members, but which the states parties in 1995 decided should be enlarged to 18 members. As of January 2001, the amendment had not entered into force and the number of expert members remains 10. The members of the committee are nominated and elected by states, but serve in their personal capacity and those covenants of other international instruments. 2.1.2. Reservations and declarations. When becoming party to a treaty, a state may, by formulating reservations, declarations and interpretive statements, seek to limit its domestic application beyond what is permissible under the limitations referred to above. Although it is desirable that states become party to a convention unconditionally, this is often not the case. 43. 2.1.2.1. Reservation. In general terms, a reservation is a statement made by a state by which it purports to exclude or alter the legal effect of certain provisions of a treaty in their application to that state. A reservation may enable a state to participate in a multilateral treaty that it would otherwise be unable or unwilling to participate in. The International Court of Justice stated in its advisory opinion on the Genocide Convention, 1951, object and purpose of the convention limit both the freedom of making reservations and that of objecting to them. These words were later codified in Article 19 of Vienna Convention on the Law of Treaties, which sets out the general rule on reservations. A state may, when signing, ratifying, accepting, approving or acceding to a treaty, formulate a reservation unless a. The reservation is prohibited by the treaty. B. The treaty provides that only specified reservations, which do not include the reservation in question, may be made for C. In cases not falling under subparagraphs A and B, the reservation is incompatible with the object and purpose of the treaty. Unless expressly permitted by a treaty, the effectiveness of a reservation is dependent on its acceptance by other states parties, and any other state party may object to it. As a rule, a reservation is considered accepted by another state party if that state party has raised no objection within 12 months after it has been notified of the reservation, Article 25 BCLT. Regrettably, silence on the part of other states parties seems to be the common response to reservations, and, unfortunately, this silence is rarely the result of conscious deliberation. The UN Commission on Human Rights has stated that reservations should be formulated, as precisely and narrowly as possible, Resolution 1998-9. Reservations often reflect an admission, opposition, that the country in question cannot or will not bring its conduct up to international standards. General reservations may, moreover, encourage other states to follow suit, and thereby. General reservations may, moreover, encourage other states to follow suit, and thereby 44. Reduce the ability of the state making the reservation to complain when other states make similar reservations. Furthermore, extensive limitations may contravene established principles of international law contrary, for instance, to Article 27 VCLT that states, a party may not invoke the provisions of its domestic law as justification for its failure to perform a treaty. Article 57(1) of the ECHR prohibits reservations, of a general character. The European Court of Human Rights discussed the issue of general reservations in Bellilos v. Switzerland, 1988. In Loizito v. Turkey, 1995, the court held that a state may not make a reservation in relation to an article of the convention that does not deal directly with substantive rights and freedoms, but instead with procedural or formal matters. If substantive or territorial restrictions were permissible under these provisions, contracting parties would be free to subscribe to separate regimes of enforcement of convention obligations. Such a system would not only seriously weaken the role of the court, but would also diminish the effectiveness of the convention as a constitutional instrument of European public order, ordre public. The Inter-American Court has dealt with the issue of reservations in its advisory opinion No. 2. On the effect of reservations on the entry into force of the American Convention on Human Rights, and advisory opinion No. 4. On proposed amendments to the naturalization provisions of the Constitution of Costa Rica, stating that reservations may not lead to a result that weakens the system of protection established by the Convention. Certain instruments, such as the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, have been subject to many reservations, some of them clearly incompatible with the object and purpose of the treaty. The effect of invalid reservations to human rights treaties, and of objections to reservations, is a continuing debate in international law. In the face of this situation, the independent monitoring bodies, such as the CEDAW Committee and the Human Rights Committee, have taken a view on the validity of reservations, a practice not contemplated by the VCLT. Although the competence of these bodies in this regard has been debated, it seems logical to conclude that their competence derives from their functions. The Human Rights Committee has dealt with this issue in General Comment 24 on. The Human Rights Committee has dealt with this issue in General Comment 24 on 45. Issues relating to reservations made upon ratification or accession to the Covenant are the optional protocols, CCPR, C. 21, Rev.1, Ad.6, of the 11th of November 1994. In this general comment the committee stressed that reservations must be specific and transparent. Reservations may thus not be general, but must refer to a particular provision of the Covenant and indicate in precise terms its scope in relation thereto. 2.1.2.2. Declarations. Some conventions allow or even require states parties to make declarations concerning the extent to which they are bound by a certain provision. Such statements may relate to the competence of a supervisory mechanism. For instance, Article 41 ICCPR stipulates that a state party may choose not to recognize the competence of the Human Rights Committee to receive state complaints regarding its human rights performance. This type of declaration, as provided by the instruments, does not pose major problems. However, a state party may also make interpretive declarations, otherwise known as understandings, whereby it does not intend to modify or limit the provisions of the treaty, but indicates merely how it interprets a particular article. Such interpretive declarations may raise certain problems in international law as to their differentiation with reservations. The VCLT is silent on the question of interpretive declarations. However, the International Law Commission has studied the matter at length and several international human rights bodies have dealt with the issue. One of the major differences between a reservation and an interpretive declaration lies in the author's purpose in making that declaration. While a reservation seeks to exclude or modify the legal effect of the treaty's provisions in their application to the state author, the interpretive declaration seeks only to clarify the meaning or scope of the treaty provisions. Therefore, it is the intention of the state rather than the form or the name or title which matters. Thus, if a statement purports to exclude or modify the legal effect of a treaty in its application to the state, it constitutes a reservation. Conversely, if a so-called reservation merely provides a state's understanding of a provision, without excluding or modifying that provision, it is in reality not a reservation. 46. 2.1.3. Restrictions and derogations 2.1.3.1. Restrictions. Conventions and other instruments may contain a number of restrictions or limitations to the rights they stipulate. It is generally accepted that only few rights and freedoms are absolute. At the same time, such restrictions must be used only to establish the proper limits of the protected right and not as an excuse for undermining the right itself or destroying it altogether. In general, there must be a proportionate relationship between the restriction of the right as such and the reason for the restriction. Various international instruments contain provisions allowing restrictions, used interchangeably with the term limitations, on human rights. Such provisions may take the form of general limitations. Article 4 of ICESCR, for instance, reads: the states parties to the present covenant recognize that, in the enjoyment of those rights provided by the state in conformity with the present covenant, the state may subject such rights only to such limitations as are determined by law only in so far as this may be compatible with the nature of these rights and solely for the purpose of promoting general welfare in a democratic society. Another illustration is provided by Article 32(2) of the American Convention on Human Rights, ACHR. The rights of each person are limited by the rights of others, by the security of all, and by the just demands of the general welfare, in a democratic society. The African Charter on Human and People's Rights does not contain a specific provision on restrictions, but Article 27(2), on duties, has come to play the role of a general limitation clause providing, the rights and freedoms of each individual shall be exercised with due regard to the rights of others, collective security, morality and common interest. In order to prevent abuse, conventions often contain a paragraph prohibiting the abuse of an international instrument to destroy another right. Article 5 of ICCPR, for instance, stipulates. Article 5 of ICCPR, for instance, stipulates 47. Nothing in the present convention may be interpreted as implying for any state, group or person any right to engage in any activity or to perform any act aimed at the destruction of any of the rights and freedoms recognized herein or at their limitation to a greater extent than is provided for in the present covenant. However, apart from these general provisions, most human rights treaties contain specific provisions in various individual articles, which specify the limitations and restrictions that are allowed on the particular right. Such specific limitation clauses include, prescribed by law, in a democratic society, public order, order public, public health, public morals, national security, public safety, and rights and freedoms of others. For a few rights, such as freedom from torture or slavery, no limitations have been formulated. When a right is subject to a limitation, no other limitations are permitted, and any limitation must comply with the following minimum requirements. The limitation must not be interpreted so as to jeopardize the essence of the right concerned. The limitation must be interpreted strictly in the light and context of the particular right. The limitation must be prescribed by law and be compatible with the object and purpose of the instrument. The restriction must be based on a law. The restriction must be necessary, there must be a pressing social need, assessed on a case-by-case basis. That the law would be useful is in itself not sufficient, it must be consistent with other protected rights. In some treaties, the condition that it be necessary in a democratic society is added, and the restriction must be justified by the protection of a strictly limited set of well-defined public interests, which usually includes one or more of the following grounds: national security, public safety, public order, order public, the protection of health or morals, and the protection of the rights and freedoms of others. 48. Most of these requirements have been developed by academia and the jurisprudence of major human rights bodies. In this regard, it is important to bear in mind the Syracuse Principles on the limitation and derogation provision in the International Covenant on Civil and Political Rights. The Syracuse Principles were adopted by a group of 31 distinguished experts in international law convened by the International Commission of Jurists, who met in Syracuse, Sicily in 1984. The Inter-American Court has dealt with limitation and derogation in Advisory Opinion No. 5. On compulsory membership in an association prescribed by law for the practice of journalism. In sum, any restriction on the enjoyment of the rights enshrined in human rights instruments must be legally established, non-discriminatory, proportional, compatible with the nature of the rights, and designed to further the general welfare. Finally, it is also important to stress that the burden falls upon states parties to prove that a limitation imposed upon the enjoyment of the rights is legitimate. This is, of course, a heavy burden of proof, but it is consistent with the object and purpose of human rights treaties to protect the individual. 2.1.3.2. Derogations. Some human rights instruments allow states to take measures derogating temporarily from some of their obligations. Derogating measures must be of an exceptional and temporary nature. There are derogation clauses in, inter alia, Article 15 of ECHR, Article 27 of ACHR and Article 31 of European Social Charter. Some human rights instruments, such as the Convention on the Right of the Child, the ICESCR, and the African Charter on Human and People's Rights, do not contemplate any derogation clause. The rationale for derogation provisions is to strike a balance between the sovereign right of a government to maintain peace and order during public emergencies, and the protection of the rights of the individual from abuse by the state. Thus, the state is allowed to suspend the exercise of some rights when necessary to deal with an emergency situation, e.g., derogation of the right to peaceful assembly, provided it complies with safeguards against any abuse of these derogation provisions. 49. When derogation measures are allowed, such derogations have to meet several criteria. There must be a war or general state of emergency threatening the life of the nation. The state of emergency must be officially proclaimed. Measures may not go beyond the extent strictly required by the situation. Measures may not be inconsistent with other obligations under international law, and measures may not be discriminatory solely on grounds of race, color, sex, language, religion, or social origin. A state availing itself of the right of derogation must immediately provide justification for its decision to proclaim a state of emergency and also for any specific measure based on such a proclamation. With regard to derogations and limitations, the final document of the 1991 Moscow meeting of the Conference on Security and Cooperation in Europe (CSCE) states, the participating states reaffirm that a state of public emergency is justified only by the most exceptional and grave circumstances. A state of public emergency may not be used to subvert the democratic constitutional order, nor aim at the destruction of internationally recognized human rights and fundamental freedoms. Opening square bracket. Closing square bracket. The participating states confirm that any derogation from obligations relating to human rights and fundamental freedoms during a state of public emergency must remain strictly within the limits provided for by international law, in particular the relevant international instruments by which they are bound, especially with respect to rights from which there can be no derogation. Limits, in the form of the criteria to be met, have thus been set out on the extent to which states can derogate from their human rights obligations. Moreover, as stipulated in a number of international conventions, e.g., Article 4.2 of ICCPR, Article 15.2 of ECHR and Article 27.2 of ACHR, a number of rights can under no circumstances be limited or derogated from. Such rights are often called Notstandsfest, a German term, and include the right to life, freedom from slavery, torture and imprisonment for death, the principle of legality in the field of criminal law, freedom of thought, conscience and religion, and the right to juridical personality. Such rights are often called Notstandsfest, a German term, and include the right to life, freedom from slavery, torture and imprisonment for death, the principle of legality in the field of criminal law, freedom of thought, conscience and religion, and the right to juridical personality. 50. The Human Rights Committee, in its General Comment 29, sets out in detail the conditions that must be met in order to derogate from the rights contained in the ICCPR and refers in length to those rights which are not derogable. The committee established that the rights contained in Article 4.2 of ICCPR are not the only non-derogable rights. There are elements of other rights not listed in Article 4.2 that cannot be subject to lawful derogation. 2.1.4. Institutions and procedures. The numerous human rights conventions under the framework of the United Nations and the regional systems in Africa, the Americas and Europe have led to the creation of a wide range of mechanisms for monitoring compliance with the standards agreed upon. Here we will examine the different procedures which have been instituted at the international and regional levels to monitor compliance with human rights treaties. There are two distinctive types of supervisory mechanism. A treaty-based mechanism, supervisory mechanisms enshrined in legally binding human rights. Instruments are conventions. Within the UN framework, these mechanisms are often called treaty bodies, e.g., the Human Rights Committee and the Committee on the Rights of the Child. The African Commission and Future Court on Human and People's Rights, the European Court and Commission of Human Rights and the Inter-American Court and Commission of Human Rights are also treaty bodies. B. Non-treaty-based mechanisms, supervisory mechanisms not based on legally binding human rights treaty obligations. Generally, this type of mechanism is based on the constitution or charter of an intergovernmental human rights forum, or on decisions taken by the assembly or a representative body of the forum in question. Under the UN framework, the non-treaty-based mechanisms are referred to as charter-based mechanisms, which include the 1503 procedure and the country mandates. The European Commission Against Racism and Intolerance under the Council of Europe is also an example of a regional non-treaty-based mechanism. 51. 2.1.4.1. Treaty-based mechanisms. The six most well-known human rights treaties are the two covenants, ICESCR and ICCPR, CERD, CEDAW, CAD and CRC. In addition, mention should be made of the CMW, which entered into force in 2003. Each of these conventions has a supervisory body. These bodies consist of a number of experts of a high moral character and recognized competence in the field of human rights. They act in their personal capacity, which means that although they are normally nationals of a state party to the treaty in question, they are not acting under instructions from respective governments. The treaty-based procedures are the mechanisms established within the context of a specific human rights treaty. The Convention on the Elimination of All Forms of Racial Discrimination, 1965, was the first human rights treaty of universal application to provide for a mechanism of supervision. This mechanism subsequently served as a model for other human rights treaties, notably the International Covenant on Civil and Political Rights. The treaty bodies, with the exception of the Committee on Economic, Social and Cultural Rights, are not organs of the UN, but derive their status from the convention concerned. To implement these conventions, regular meetings of states parties are held to discuss issues regarding the conventions, mainly in connection with the election of members to the treaty bodies. The various supervisory procedures established in human rights treaties can be divided into four main groups. Reporting procedures, interstate complaint procedure, individual complaint procedure, inquiries and other procedures. Reporting procedures. Most human rights treaties include a system of periodic reporting. States parties to them are obliged to report periodically to a supervisory body on the implementation at the domestic level of the treaty in question. Is formulated, e.g., in Article 40 of the ICCPR, states parties shall. Is formulated, e.g., in Article 40 of the ICCPR, states parties shall. 52. Submit reports on the measures they have adopted which give effect to the rights recognized herein and on the progress made in the enjoyment of those rights. At the UN level, each treaty body has formulated general guidelines regarding the form and contents of the reports to be submitted by states parties as envisaged, HRI, Gen. 2, Rev.2, and their own rules of procedures, UNHRI, Gen. 3, Rev.1. The report is analyzed by the relevant supervisory body, which comments on the report and may request the state concerned to furnish more information. In general, reporting procedures under the different treaty-based mechanisms are meant to facilitate and initiate a dialogue between the supervisory body and the state party. The quality of the reports submitted by states varies. Some reports are reliable and reflect serious efforts to comply with the reporting requirements, while others are lacking in credibility. In any case, the reports generally reflect the view of the respective state. In addition to the government report, the treaty bodies receive information on a country's human rights situation from other sources, including non-governmental organizations, UN agencies, other intergovernmental organizations, academic institutions, and the press. The quality of decision-making throughout the reporting procedure depends to a great extent on this additional information that the experts may receive from the external sources. Additional information provided by, in particular, NGOs and agencies of the United Nations grant a wider perspective as to the actual situation in the country concerned. In an increasing number of countries, NGOs prepare and submit to the treaty bodies alternative reports aimed at counterbalancing the information submitted by the state. In the light of all the information available, the committees examine the reports together with government representatives. Based on this dialogue, the committees decide on their concerns and recommendations to the state concerned, referred to as concluding observations. All UN human rights conventions contain a reporting procedure, Article 16 of ICESCR, Article 40 of ICCPR, Article 9 of CERD, Article 19 CAT, Article 44 of CRC, Article 18 of CEDAW and Article 73 of CMW. All UN human rights conventions contain a reporting procedure, Article 16 of ICESCR, Article 40 of ICCPR, Article 9 of CERD, Article 19 CAT, Article 44 of CRC, Article 18 of CEDAW and Article 73 of CMW. 53. E. Interstate complaint procedure. Some human rights instruments allow states parties to initiate a procedure against another state party, which is considered not to be fulfilling its obligations under the instrument. In most cases, such a complaint may only be submitted if both the claimant and the defendant state have recognized the competence of the supervisory body to receive this type of complaint. The possibility to lodge complaints against another state party is contemplated in, inter alia, Article 41 of ICCPR, Article 21 of CAT, Article 11 of CERD. In practice, interstate complaint mechanisms are seldom used. Interstate relationships are delicate and interstate mechanisms may not be ideal procedures as states bringing complaints may elicit reprisals. In addition, many states have not recognized the competence of the supervisory bodies to receive interstate complaints. E. Individual complaint procedure. It seems reasonable that individuals, on whose behalf human rights were stipulated in the first place, should be enabled to initiate proceedings to protect their rights. Such a procedure, whereby an individual holds a government directly accountable before an international supervisory body, aims to afford far-reaching protection to the individual. In order for an individual to bring a case, communication, petition under a human rights convention, the following requirements have to be met. A. The alleged violating state must have ratified the convention invoked by the individual. B. The rights allegedly violated must be covered by the convention concerned. And C. Proceedings before the relevant body may only be initiated after all domestic remedies have been exhausted. At the UN level, individual complaint mechanisms are found under 5 conventions, in the first optional protocol to the ICCPR, Article 22 of CAT, optional protocol to the CEDAW, Article 14 of CERD and Article 77 of CMW. Individual complaints under one of the above-mentioned treaties can be brought only against a state that has recognized the competence of the committee established under the relevant treaty or become party to the relevant optional protocols. In the case of the ICCPR and the CEDAW, a state recognizes the committee's competence by becoming a party to an optional protocol, which has being added to the ICCPR and the CEDAW. In the case of the ICCPR and the CEDAW, a state recognizes the committee's competence by becoming a party to an optional protocol, which has being added to the ICCPR and the CEDAW. 54. In the case of the CAT and the CERD, states recognize the committee's competence by making an express declaration under Articles 22 and 14 respectively. Anyone under the jurisdiction of a state party can lodge a complaint with a committee against a state that satisfies this condition, claiming that his or her rights under the relevant treaty have been violated. There is no formal time limit after the date of the alleged violation for filing a complaint under the relevant treaties, but the victim should submit a complaint as soon as possible after having exhausted domestic remedies. While there are some procedural variations between the different UN treaties, their design and operation are very similar. In general terms, the system works as follows. Once a complaint, which should comply with some basic requirements, is submitted, the case is registered and transmitted to the state party concerned to give it an opportunity to comment. The state is requested to submit its observations within a set time frame which varies between procedures. The 2 major stages in any case are known as the admissibility stage and the merits stage. The admissibility of a case refers to the formal requirements that the complaint must satisfy before the relevant committee can consider its substance. The merits of the case are the substance, on the basis of which the committee decides whether or not the rights under a treaty have been violated. Once the state replies to the complaint, the alleged victim is offered an opportunity to comment. Again, the time frames vary somewhat between procedures. At this point, the case is ready for a decision by the relevant committee. If the state party fails to respond to the complaint, the committee may take a decision on the case on the basis of the original complaint. There is no appeal against committee's decisions. When a committee decides that the state party has violated a right or rights enshrined in the treaty, it invites the state party to supply information within a given time limit on the steps it has taken to give effect to the committee's findings. D. Inquiries and other procedures. The group of supervisory mechanisms now discussed includes all procedures that do not fall under those mentioned above. Most involve inquiries, but others may entail initiatives aimed at. Most involve inquiries, but others may entail initiatives aimed at. 55. preventing violations or promoting compliance with specific human rights. The supervisory bodies discussed above play a rather passive role as they generally cannot initiate proceedings, and are largely dependent on information submitted by governments, or individual plaintiffs or petitioners. Recently, however, several supervisory mechanisms have been established whereby an independent person or group of persons may raise, on the person's or group's own initiative, issues of non-compliance with human rights. Such a body may, for instance, act upon receipt of complaints or take an initiative itself. It may also initiate a visit in loco to gather information, or do so as part of a regular visit program. One example of a visit program, an enquiry, and in loco visits procedure, is that set out in Articles 126 and 132 of the Third Geneva Convention, 1949, and the provision in Article 143 of the Fourth Geneva Convention providing for on-site visits to places of internment or detention. Mention should also be made of the International Fact-Finding Commission established under Article 90 of Protocol I to the Geneva Conventions. 2.1.4.2. Non-treaty-based, charter-based mechanisms. A. International Court of Justice, ICJ. The International Court of Justice is the principal judicial organ of the United Nations. Its statute is an integral part of the Charter of the United Nations and, consequently, all member states of the United Nations are ipso facto parties to the statute of the court. Only states may be parties in cases before the courts, and the jurisdiction of the court will comprise all cases which the parties refer to it. In addition, states parties to the statute may at any time declare that they recognize as compulsory ipso facto and without special agreement, in relation to any other state accepting the same obligation, the jurisdiction of the court in all legal disputes concerning a. the interpretation of a treaty, b. any fact which, if established, would constitute a breach of an international obligation, and d. the nature or extent of the reparation to be made for the breach of an international obligation. The General Assembly or the Security Council may request the court to give an advisory opinion on any legal question. Other organs of the United Nations and specialized agencies, which may. The General Assembly or the Security Council may request the court to give an advisory opinion on any legal question. Other organs of the United Nations and specialized agencies, which may 56. at any time be so authorized by the General Assembly, may also request advisory opinions of the court on legal questions arising within the scope of their activities. A number of human rights instruments contain provisions whereby any dispute between the contracting states relating to the interpretation, application or fulfillment of the instrument may be submitted to the court at the request of any of the parties to the dispute. However, neither the ICCPR nor the ICESCR specifically provides for adjudication by the court. B. Security Council. Under the Charter of the United Nations, member states have conferred on the Security Council primary responsibility for the maintenance of international peace and security, and have agreed that in carrying out its duties under this responsibility, the Security Council acts on their behalf. The Security Council may investigate any dispute, or any situation which might lead to international friction or give rise to a dispute, in order to determine whether the continuance of the dispute or situation is likely to endanger the maintenance of international peace and security. Any member of the United Nations may bring such dispute to the attention of the Security Council. When the Security Council determines the existence of any threat to the peace, breach of peace, or act of aggression, it may make recommendations, or decide what measures shall be taken to maintain or restore international peace and security. Measures which the Security Council may initially take include complete or partial interruption of economic relations and of rail, sea, air, postal, telegraphic, radio, and other means of communication, and the severance of diplomatic relations. If such measures would be, or prove to be, inadequate, it may take such action by air, sea, or land forces as may be necessary to maintain or restore international peace and security. The Security Council has dealt with several human rights problems, including massive and repeated violations in South Africa, Somalia, Haiti, Yugoslavia, and Rwanda, the situation in the occupied Arab territories, the instances of hostage and abduction. The Security Council has dealt with several human rights problems, including massive and repeated violations in South Africa, Somalia, Haiti, Yugoslavia, and Rwanda, the situation in the occupied Arab territories, the instances of hostage and abduction. 57. C. United Nations General Assembly. One of the functions of the United Nations General Assembly is to initiate studies and make recommendations for the purpose of assisting in the realization of human rights and fundamental freedoms for all without distinction as to race, languages or religion. Such matters are usually referred by the General Assembly to its third committee, which deals with social, humanitarian and cultural matters. The General Assembly has established a number of subsidiary organs which are concerned with human rights. These include, a. The International Law Commission, whose object is the promotion of the progressive development of international law and its codification. Among the international human rights instruments it has prepared are the Genocide Convention, the Refugees Convention, the conventions relating to the status of stateless persons and the reduction of statelessness, the Declaration on Territorial Asylum, and the Statute of the Office of the United Nations High Commissioner for Refugees. B. The Office of the United Nations High Commissioner for Refugees, which provides protection and assistance for refugees and other displaced persons. C. The Special Committee on Declaration, or the Committee 24, whose principal function is to monitor the implementation of the Declaration on the Granting Independence to Colonial Countries and Peoples. D. Committee on the Exercise of the Inalienable Rights of the Palestinian People, which was required to consider and recommended to the General Assembly a program of implementation designed to enable the Palestinian people to exercise its inalienable rights in Palestine, including the right to self-determination and the right to return to their homes and property from which they had been displaced and uprooted. D. Economic and Social Council. The Economic and Social Council is authorized by the Charter of the United Nations to make recommendations for the purpose of promoting respect for, and observance of human rights and fundamental freedoms for all. In connections to this function, it is also authorized to prepare draft conventions for submission to the General Assembly, to call international conferences, and in connections to this function, it is also authorized to prepare draft conventions for submission to the General Assembly, to call international conferences, and 58. To obtain reports from member states on the steps taken to give effect to its recommendations and to those of the General Assembly, and to communicate its observations on these reports to the General Assembly. ECOSOC may also furnish information to the Security Council. Acting on the authority of the Charter, one of the first decisions of ECOSOC was to establish the Commission on Human Rights and the Commission on the Status of Women. ECOSOC is a political body which originally comprised lieutenants members but now consists of 54 members of the United Nations elected by the General Assembly. It normally holds an organizational session and 2 regular sessions each year. Human rights items are usually referred to the first session of the Social Committee, on which all 54 members are represented. E. UN Human Rights Council. The Commission on Human Rights is the principal functional organ of the United Nations concerned with human rights. It consists of 53 members, all states, who are elected from time to time by ECOSOC. These 53 states are elected on a geographical basis and represent a cross-section of the world in many respects. The Commission is essentially a political body, and its states members include those whose human rights records range from the good to the dismissal. Yet, it is this body that drafted the UDHR, the ICCPR and ICESR, and all the principal human rights instruments. In addition to representatives of its states members, sessions of the Commission may be attended by representative of any member state of the United Nations which is not represented on the Commission but is invited to participate in its deliberations, and by observers from states members and non-members of the United Nations not represented on the Commission, and from United Nations bodies, specialized agencies, other intergovernmental organizations concerned with human rights, national liberation movements, and non-governmental organizations in consultative status with ECOSOC. F. International Lab Hour Organizations, ILO. The ILO has long been concerned with labor rights, first as parallel organization to the League of Nations, then as a specialized agency of the UN system. It has developed several complicated 59 procedures for monitoring state behavior in the area of labor rights. In general, certain differences aside, its record on helping apply international labor rights is similar to that of the UN Human Rights Commission in 2 respects. It proceeds according to indirect implementation efforts falling short of direct enforcement, and its exact influence is difficult to specify. It is concerned with economic and social rights, such as the right to work, the right to just and favorable conditions of work, the right to form and join trade unions, the right to social security, and the right to an adequate standard of living. It is also concerned with civil and political rights such as the freedom of expression, the freedom of association, and the freedom of peaceful assembly. The ILO seeks to lay down standards in respect of these rights. Among the human rights conventions adopted by the General Conference of the ILO are the following: A. Convention concerning freedom of association and protection of the right to organize. B. Convention concerning the application of the principles of the right to organize and to bargain collectively. C. Convention concerning equal remuneration for men and women workers for work of equal value. D. Convention on the abolition of forced labor. E. Convention concerning discrimination in respect of employment and occupation. F. Convention concerning employment policy. G. Convention concerning protection and facilities to be afforded to workers' representatives in the undertaking. H. Convention concerning protection of the right to organize and procedures for determining conditions of employment in the public service. I. Convention concerning the promotion of collective bargaining. J. Convention concerning employment promotion and protection against unemployment. K. Convention concerning indigenous and tribal peoples in independent countries. The ILO supervises the application of the standards it has laid down through tripartite composed or representatives of governments, workers and employers' bodies. Among them is the 20-member Committee of Experts on the Application of Conventions and Recommendations which among them is the 20-member Committee of Experts on the Application of Conventions and Recommendations which 60 meets annually in March to examine periodic reports submitted by each member state on the measures it has taken to give effect to the conventions it has ratified. The 9-member Committee on Freedom of Association of the ILO Governing Board examines complaints against member states of infringement of the right to freedom of association. 2.2 Regional Human Rights Systems. 2.2.1 The European